Hi everyone, I hope all of you are doing well. So, welcome back to my series, and in this third segment, I'll try my best to share some insights regarding the oral advocacy. Now, first of all, coming to the speech straight away, what you need to do is you should have one detailed speech initially prepared, and slowly you should move towards cutting it short and preparing your preliminary round speech. So, my first approach as a mooter was to prepare the speech for the final round. The reason for that was I used to consider at least three judgments per issue. That means I had three judgments for every argument that I was making. Secondly, I used to have a lot of anticipatory questions and the answers ready for the same on the left side of my speech, as in on the page. That used to benefit me that, for example, if I'm arguing issue X, and if X is interrelated to issue Y, and the judge is asking me a question from issue Y, which I knew for sure was going to crop up, then I also have a judgment to answer that question coming out of issue Y. That is the kind of benefit you will have if you have this kind of a lengthy speech ready, because it will definitely help you to have some good grip over the domain knowledge and the area of law that you are dealing with. More importantly, the benefit of that is the judge will appreciate that you also anticipated a question, and you anticipated to the extent that you also researched another case law on that issue. And I think that will definitely help. So having a detailed speech gives you that opportunity to include all these kind of things in your speech. And slowly what happens is once you realize, by the times of your research and by the efforts, more and more research, you will for sure realize that what are the primary issues that should be argued in the preliminary rounds, what are the key points that should be taken care of by the councils when they argue in the rounds, and therefore you can accordingly prepare that short speech, basically taking stuff out from the detailed speech itself. There's nothing to be fundamentally different from the previous speech. All you need to do is have one case law for each issue. Now, adjudge what will be the primary issues that you should have, and accordingly build your case. Right? That's how you actually proceed towards having good speeches. More importantly, having a detailed speech much before the preliminary round itself will give you thorough clarity even while answering questions in preliminary rounds. Now, in preliminary rounds, if they ask you a question, well, obviously, you understand that the time is say just 12 minutes, 12 minutes with you, but you have not covered a lot of issues, or covered a lot of judgments, but you know them because you have already prepared your detailed speech and every research is ready with you. So any question that comes your way will definitely be answered more effectively if you have such a practice followed, right? Secondly, how to engage the bench properly during the rounds is have a compendium ready. Now, for those who do not know what a compendium is, it's a list of documents having all sources of law in the same chronology with which you mention it in your speech. So, if your speech has 20 case laws, Indian Law Commission reports, other sources of law, etc., which may have some persuasive value also, and maybe include it, will include all research documents, it will include all forensic science data, etc., if you are so using, as we had also discussed in the previous session. Any research document that you are going to cite, that you want the judge to see, make sure you carry a copy of the same, compile all of that in the same chronology as you are going to cite them in your rounds into the compendium, spiral bound the compendium, place the compendium right, when the rounds start with the judges, place it on record. And then what you can do is number the compendiums, flag them and number them in the same chronology. For example, in the speech, if you have like numbers 1 to 20, please have, and write in the compendium and flag them as 1 to 20 itself. Do not write the whole name of the judgments in the flags, because first of all they're very tiny and it might take some time for the judge to actually see it and then open it. And therefore what you can actually do is just write the numbers and write the corresponding numbers even in the speech. So what you do during the rounds is, while arguing, without even referring to the compendium, the fact that it's there in your speech itself, which you are even not referring because the enormous practice that you have actually done so far as your speech is concerned, just do this. Your lordships may kindly refer to flag number 1 of the compendium, which deals with case A versus B, And I'm quoting para 45 of the judgment, wherein the Constitution bench decision, Justice this, etc., etc., has stated as this. That is where you can actually take the bench to the exact para, quote the para. What the judge is of the view that, okay, you are not even referring to the compendium, but you are able to cite the judge with absolute judgment with absolute clarity, and that is very, very essential as a matter of trust you gain from the bench, because whatever you are going to cite has documentary backing. That's very essential because you won't be doubted for everything you speak or argue. So it's a kind of a mind game, if I would say, because if you are arguing something, if the judge is able to appreciate that argument because there is a document in place, I'm sure you at least get 50% of your marks right over there, because they hardly doubt you. It's for sure that you are not misleading the bench. More importantly, it saves a lot of your time. The reason is I've seen multiple councils requesting the researchers to stand time and again and pass documents to the bench. That takes away a lot of time. It disrupts the court proceedings. 10 seconds every time taken, say 10 times he passes a document, means 100 seconds wasted. That means over in 1.5 minute wasted of your time, which is just maybe 12 or 13 minutes. That way, what you can do is compendiums are a very, very effective way. And more importantly, if whatever you want to cite, just time and again refer to the compendium before you want to go to the judgment. Do not read the whole judgment and then say it's there at flag 3. There's no purpose because the judge will not be able to follow you. Therefore, please understand that whenever you're quoting any judgment, refer to the compendium flag number, corresponding speech you will be having with you. Just refer it then and there, and that's a very, very good approach, even to engage the bench. Because please understand that judges may have a tendency to, even fall asleep if you're not engaging them well, and therefore it's very important to engage them through the compendiums, through the fact sheets. And if I may also recollect one instance and tell you that if someone asks me as to what should be there in your fact sheet, or say if there is a question, in fact, as to how do you adduce a particular fact and where are you adducing it from, my immediate response, even without looking at the fact sheet, would have been, your lordships is there at para 5, sentence 7, page 3 of the document. That's the kind of grip you will require if you want to succeed in orals. So please follow these small tips. I'm sure it may definitely help you in your next rounds. Next, what you may also keep in mind is your caliber of putting up a good research. Now I'll just give you one tip over here. You may have case A mentioned in a memorial, but in the oral rounds please have case B which says the very same thing. The reason is the other side will have no clue that you are coming up with a new judgment. It's definitely allowed to go for new judgments. That's not an issue at all. Obviously, you cannot go and bypass the issue altogether. You can definitely cite more and more questions on law, judgments on law, and the legal points can be the same. Therefore, you can actually use that tactic a bit, use judgments differently. That's a very good practice where you can actually, not give an opportunity to the other side to come and counter you in the rebuttals. So, next, what I should cover in this small session is you should again follow IRAC. I have already discussed about IRAC in my second session in detail, where you need to follow the issue, rule, analysis, and conclusion format, and you need to be structural throughout your rounds. It's very, very essential to have court mannerisms. It's very essential to have the etiquettes maintained. It's also very essential to have a structure laid down for every argument. For example, if you're arguing something, please make sure that you are explaining the broader, or rather the model of the arguments right at the outset. So if you have a threefold submission, make sure you mention that, your lordships, I do have a threefold submission regarding this issue, wherein my first argument deals with dash, second argument deals with this, and thirdly I'll be covering this aspect. So if you state this at the outset, it will leave a good impression in the mind of the judge that, okay, these are the things he's going to cover in the rounds. And more importantly, you are also apprising the bench that these are the issues that will be covered in the overall rounds, and in case you run out of time, you are not left with any further time, then at least the judge will understand that, okay, it was because of lots of questions maybe that he could not cover the third issue, but the fact that you have at least told him that your third issue is X, the knowledge in the mind of the judge will be enough, because maybe the judge was expecting you to cover that issue. Had you not put that model right at the outset, he may just think that you have missed on that issue, and therefore put lesser marks in the category of knowledge of law. Therefore, please do not leave any ambiguity in your speech. Try your best to be absolutely structural. It's very important to be structured in your arguments. Last thing I should mention about the speech is how you should deal with the questions. First of all, please understand that lots of judges do have a tendency to heckle a participant, some with a good intention, some with a bad intention. Now, I do not want to comment on the latter, but definitely people who heckle with good intentions are ideally to test the patience of the students as to how well they can actually have some patience and comprehend the issues well and just focus on answering the judges. If they ask pertinent questions, and even if it's a Q&A session throughout the rounds, please make sure that your primary responsibility is to answer the queries of the bench. You need not bother about whether you are able to cover your remaining issues or not, because please understand that judges do know that if they're asking a lot of questions, obviously the student does not have the time to cover all issues. Secondly, they also know that you having put a good amount of 3 or 4 months preparation into the mood, you will definitely come and speak out your heart so far as your speech is concerned. But what has to be tested is how good are you with the knowledge of law, how well do you know your facts, how well are you analyzing things, and make sure that even I think this point should be taken note of, that whenever you're citing a judgment, make sure you analyze the facts of that case and show and prove to the bench as to why that's also applicable to your facts, given the facts and circumstances of that particular case. Because please understand that a ratio will not apply verbatim to every judgment or every subsequent proceeding as precedent. It will only have precedent value if the facts and the issues are quite similar to each other. Therefore, you need to make sure that you can't just stand up and quote Kesavananda Bharati and say that it will apply to each and every judgment, no matter how different the facts are. Provided the facts are same, I'm sure you can use the judgment. But if the facts are fundamentally different from each other, you cannot cite a judgment into that context and use it as precedent. Therefore, I think you should just keep these few things in mind. I hope you will definitely perform well in the rounds. Lastly, just restrict your reliefs to crystal clear as to what you want. Do not claim anything extra. More importantly, do not make them verbose. Just ask for what you want, what your client wants. The whole purpose should be served, because it's very essential to have very pointed reliefs, because if you fault in your prayer, that is where you give the loophole kind of a thing and give a leeway to the other side to haunt upon you. And therefore you should not be careless in your prayer. Make sure your prayer is absolutely correct. Make sure you do not commit any errors in the prayer, right? So that's all I wanted to cover in this session. I hope that was of some use, because see, I feel that oral advocacies ultimately depend a lot on an individual, and that will the style in which you speak will also vary from individual to individual. What matters is the research and not how you speak. Therefore, each and every focus should be on rational arguments and engaging the bench. Have a good eye contact with the judges, have good mannerisms, focus more on answering questions, and I'm sure you will do well in the rounds. All the best, guys. This was the last video of this session. Thank you so much for being a part of this small initiative of Column of Curae, and I'm grateful that I'm a part of that initiative. Thank you so much. I wish that will soon have physical participation in the national moot court competitions post COVID, and I hope that all of you will in fact participate in great numbers. Thank you so much.